The true nature of constitutional law. Burke writes in 1791, quote, "Great critics have taught us one essential rule. It is this, that if ever we should find ourselves disposed not to admire those writers or artists, Livy and Virgil for instance, Raphael or Michelangelo, whom all the learned had admired, not to follow our own fancies, but to study them until we know how and what we ought to admire, and if we cannot arrive at this combination of admiration with knowledge, rather to believe that we are dull, than that the rest of the world has been imposed on. It is as good a rule, at least, with regard to this admired constitution (of England). We ought to understand it according to our measure, and to venerate where we are not able presently to comprehend." Hallam writes in 1818, quote, "No unbiased observer who derives pleasure from the welfare of his species can fail to consider the long and uninterruptedly increasing prosperity of England as the most beautiful phenomenon in the history of mankind. Climates more propitious may impart more largely the mere enjoyments of existence, but in no other region have the benefits that political institutions can confer been diffused over so extended a population, nor have any people so well reconciled the discordant elements of wealth, order, and liberty. These advantages are surely not owing to the soil of this island, nor to the latitude in which it is placed, but to the spirit of its laws, from which, through various means, the characteristic independence and industriousness of our nation have been derived. The constitution, therefore, of England must be to inquisitive men of all countries, far more to ourselves, an object of superior interest, distinguished especially as it is from all free governments of powerful nations, which history has recorded by its manifesting, after the lapse of several centuries, not merely no symptom of irretrievable decay, but a more expansive energy." End quote. These two quotations from authors of equal, though of utterly different celebrity, recall with singular fidelity the spirit with which our grandfathers and our fathers looked upon the institutions of their country. The Constitution was to them, in the quaint language of George III, the most perfect of human formations. It was to them not a mere polity to be compared with the government of any other state, but so to speak a sacred mystery of statesmanship. It had, as we have all heard from our youth up, not been made, but had grown. It was the fruit not of abstract theory, but of that instinct which, it is supposed, has enabled Englishmen, and especially uncivilized Englishmen, to build up sound and lasting institutions, much as bees construct a honeycomb, without undergoing the degradation of understanding the principles on which they raise a fabric more subtly wrought than any work of conscious art. The Constitution was marked by more than one transcendent quality which in the eyes of our fathers raised it far above the imitations, counterfeits, or parodies which have been set up during the last 100 years throughout the civilized world. No precise date could be named as the day of its birth, no definite body of persons could claim to be its creators, no one could point to the document which contained its clauses. It was in short a thing by itself, which Englishmen and foreigners alike should venerate where they are not able presently to comprehend. The present generation must of necessity look on the Constitution in a spirit different from the sentiment either of 1791 or 1818. We cannot share the religious enthusiasm of Burke, raised as it was to the temper of fanatical adoration by just hatred of those doctors of the modern school who, when he wrote, were renewing the rule of barbarism in the form of the Reign of Terror. We cannot exactly echo the fervent self-complacency of Hallam, natural as it was to an Englishman who saw the institutions of England standing and flourishing at a time when the attempts of foreign reformers to combine freedom with order had ended in ruin. At the present day, students of the Constitution wish neither to criticise nor to venerate, but to understand, and a professor whose duty it is to lecture on constitutional law must feel that he is called upon to perform the part neither of a critic, nor of an apologist, nor of a eulogist, but simply of an expounder. His duty is neither to attack nor to defend the Constitution, but simply to explain its laws. He must also feel that, however attractive be the mysteries of the Constitution, he has good reason to envy professors who belong to countries such as France, Belgium, or the United States, endowed with constitutions of which the terms are to be found in printed documents, known to all citizens and accessible to every man who is able to read. Whatever may be the advantages of a so-called unwritten constitution, its existence imposes special difficulties on teachers bound to expound its provisions. Anyone will see that this is so who compares for a moment the position of writers such as Kent or Story, who commented on the Constitution of America, with the situation of any person who undertakes to give instruction in the constitutional law of England. When these distinguished jurists delivered, in the form of lectures, commentaries upon the Constitution of the United States, they knew precisely what was the subject of their teaching and what was the proper mode of dealing with it. The theme of their teaching was a definite, assignable part of the law of their country. It was recorded in a given document to which all the world had access, namely, the Constitution of the United States, established and ordained by the people of the United States. The articles of this Constitution fall indeed far short of perfect logical arrangement and lack absolute lucidity of expression, but they contain, in a clear and intelligible form, the fundamental law of the Union. This law, be it noted, is made and can only be altered or repealed in a way different from the method by which other enactments are made or altered. It stands forth, therefore, as a separate subject for study. It deals with the legislature, the executive, and the judiciary, and by its provisions for its own amendment, indirectly defines the body in which resides the legislative sovereignty of the United States. Story and Kent therefore knew with precision the nature and limits of the department of law on which they intended to comment. They knew also what was the method required for the treatment of their topic. Their task as commentators on the Constitution was in kind exactly similar to the task of commenting on any other branch of American jurisprudence. The American lawyer has to ascertain the meaning of the articles of the Constitution in the same way in which he tries to elicit the meaning of any other enactment. He must be guided by the rules of grammar, by his knowledge of the common law, by the light, occasionally, thrown on American legislation by American history, and by the conclusions to be deduced from a careful study of judicial decisions. The task, in short, which lay before the great American commentators was the explanation of a definite legal document in accordance with the received canons of legal interpretation. Their work, difficult as it might prove, was work of the kind to which lawyers are accustomed, and could be achieved by the use of ordinary legal methods. Story and Kent, indeed, were men of extraordinary capacity. So, however, were our own Blackstone, and at least one of Blackstone's editors. If, as is undoubtedly the case, the American jurists have produced commentaries on the Constitution of the United States utterly unlike, and one must in truth add vastly superior to, any commentaries on the constitutional law of England, their success is partly due to the possession of advantages denied to the English commentator or lecturer. His position is entirely different from that of his American rivals. He may search the statute book from beginning to end, but he will find no enactment which purports to contain the articles of the Constitution. He will not possess any test by which to discriminate laws which are constitutional or fundamental from ordinary enactments. He will discover that the very term constitutional law, which is not, unless my memory deceives me, ever employed by Blackstone, is of comparatively modern origin, and in short that before commenting on the law of the Constitution he must make up his mind what is the nature and the extent of English constitutional law. His natural, his inevitable resource is to recur to writers of authority on the law, the history, or the practice of the Constitution. He will find, it must be admitted, no lack of distinguished guides. He may avail himself of the works of lawyers such as Blackstone, of the investigations of historians such as Hallam or Freeman, and of the speculations of philosophical theorists such as Bagehot or Hearn. From each class he may learn much, but for reasons which I am about to lay before you for consideration, he is liable to be led by each class of authors somewhat astray in his attempt to ascertain the field of his labours and the mode of working it. He will find, unless he can obtain some clue to guide his steps, that the whole province of so-called constitutional law is a sort of maze in which the wanderer is perplexed by unreality, by antiquarianism, and by conventionalism. Let us turn first to the lawyers, and as in duty bound to Blackstone. Of constitutional law as such there is not a word to be found in his commentaries. The matters which appear to belong to it are dealt with by him in the main under the head Rights of Persons. The book, which is thus entitled, treats, inter alia, of the Parliament, of the King in his title, of master and servant, of husband and wife, of parent and child. The arrangement is curious and certainly does not bring into view the true scope or character of constitutional law. This, however, is a trifle. The book contains much real learning about our system of government. Its true defect is the hopeless confusion both of language and of thought introduced into the whole subject of constitutional law by Blackstone's habit, common to all the lawyers of his time, of applying old and inapplicable terms to new institutions, and especially of ascribing in words to a modern and constitutional king the whole, and perhaps more than the whole, of the powers actually possessed and exercised by William the Conqueror. Blackstone writes, quote, "We are next to consider those branches of the royal prerogative which invest thus our sovereign lord, thus all perfect and immortal in his kingly capacity, with a number of authorities and powers, in the exertion whereof consists the executive part of the government. This is wisely placed in a single hand by the British Constitution, for the sake of unanimity, strength, and dispatch. Were it placed in many hands, it would be subject to many wills. Many wills, if disunited and drawing different ways, create weakness in a government, and to unite those several wills and reduce them to one is a work of more time and delay than the exigencies of state will afford. The King of England is therefore not only the chief, but properly the sole magistrate of the nation, all others acting by commission from and in due subordination to him. In like manner as, upon the great revolution of the Roman state, all the powers of the ancient magistracy of the Commonwealth were concentrated in the new emperor, so that, as Gravina expresses it,
in eius tunius personas veteris republicae visatque majestas per cumulatas magistratuum potestates exprimebatur?"
End quote. The language to this passage is impressive. It stands curtailed, but is in substance unaltered in Stephen's commentaries. It has but one fault. The statements it contains are the direct opposite of the truth. The executive of England is in fact placed in the hands of a committee called the Cabinet. If there be any one person in whose single hand the power of the state is placed, that one person is not the king, but the chairman of the committee, known as the Prime Minister. Nor can it be urged that Blackstone's description of the royal authority was a true account of the powers of the king at the time when Blackstone wrote. George III enjoyed far more real authority than has fallen to the share of any of his descendants. but it would be absurd to maintain that the language I have cited painted his true position. The terms used by the commentator were, when he used them, unreal and known to be so. They have become only a little more unreal during the century and more which has since elapsed. Quote, "The king is considered in domestic affairs as the fountain of justice and general conservator of the peace of the kingdom. He therefore has alone the right of erecting courts of judicature, for, though the constitution of the kingdom hath entrusted him with the whole executive power of the laws, it is impossible as well as improper that he should personally carry into execution this great and extensive trust. It is consequently necessary that courts should be erected to assist him in executing this power, and equally necessary that if erected, they should be erected by his authority, and hence it is that all jurisdictions of courts are either mediately or immediately derived from the crown. Their proceedings run generally in the king's name, they pass under his seal, and are executed by his officers." End quote. Here we are in the midst of unrealities or fictions. Neither the king nor the executive has anything to do with erecting courts of justice. We should rightly conclude that the whole cabinet had gone mad if tomorrow's Gazette contained an order in council not authorised by statute erecting a new court of appeal. It is worthwhile here to note what is the true injury to the study of law produced by the tendency of Blackstone and other less famous constitutionalists to adhere to unreal expressions. The evil is not merely or mainly that these expressions exaggerate the power of the crown. For such conventional exaggeration a reader could make allowance as easily as we do for ceremonious terms of respect or of social courtesy. The harm wrought is that unreal language obscures or conceals the true extent of the powers both of the king and of the government. No one, indeed but a child, fancies that the king sits crowned on his throne at Westminster and in his own person administers justice to his subjects, but the idea entertained by many educated men, that an English king or queen reigns without taking any part in the government of the country, is not less far from the truth than the notion that Edward VII ever exercises judicial powers in what are called his courts. The oddity of the thing is that to most Englishmen the extent of the authority actually exercised by the Crown, and the same remark applies, in a great measure, to the authority exercised by the Prime Minister and other high officials, is a matter of conjecture. We have all learnt from Blackstone and writers of the same class to make such constant use of expressions which we know not to be strictly true to fact, that we cannot say for certain what is the exact relation between the facts of constitutional government and the more or less artificial phraseology under which they are concealed. Thus to say that the king appoints the ministry is untrue. It is also, of course, untrue to say that he creates courts of justice, but these two untrue statements each bear a very different relation to actual facts. Moreover, of the powers ascribed to the Crown, some are in reality exercised by the government, whilst others do not in truth belong either to the king or to the ministry. The general result is that the true position of the Crown, as also the true powers of the government, are concealed under the fictitious ascription to the sovereign of political omnipotence, and the reader of, say, the first book of Blackstone can hardly discern the facts of law with which it is filled under the unrealities of the language in which these facts find expression. Let us turn from the formalism of lawyers to the truthfulness of our constitutional historians. Here, a student or professor troubled about the nature of constitutional law finds himself surrounded by a crowd of eminent instructors. He may avail himself of the impartiality of Hallam. He may dive into the exhaustless erudition of the Bishop of Oxford. He will discover infinite parliamentary experience in the pages of Sir Thomas May and vigorous common sense combined with polemical research in Mr. Freeman's Growth of the English Constitution. Let us take this book as an excellent type of historical constitutionalism. The Growth of the English Constitution is known to everyone. Of its recognised merits, of its clearness, of its accuracy, of its force, it were useless and impertinent to say much to students who know, or ought to know, every line of the book from beginning to end. One point, however, deserves a special notice. Mr. Freeman's highest merit is his unrivalled faculty for bringing every matter under discussion to a clear issue. He challenges his readers to assent or deny. If you deny, you must show good cause for your denial, and hence may learn fully as much from rational disagreement with our author as from unhesitating assent to his views. Take, then, the Growth of the English Constitution as a first-rate specimen of the mode in which an historian looks at the Constitution. What is it that a lawyer, whose object is to acquire the knowledge of law, will learn from its pages?